You probably believe that when you buy a house in America, you own what is on it and what is under it. You do not. In most American states west of the Mississippi, the water beneath your land can be legally owned by someone else. A foreign company, a private equity firm, a bottled water corporation, a farm headquartered in another country. They can pump it dry. They are pumping it dry. And while they pump, you still pay your monthly water bill. This is the story of how American property law was rewritten to separate Americans from the water under their feet, and who profits from the separation. American water law is divided in two. In eastern states, where rivers flow year-round, the law generally follows what is called the riparian doctrine. If you own land next to a body of water, you have the right to use that water reasonably. Your right is tied to the land. In western states, where water is scarce, the law follows a different doctrine: prior appropriation. First in time, first in right. Under prior appropriation, the first person or company to divert water for what the law calls a beneficial use takes priority. That right is not tied to owning the land where the water flows or sits. The right can be sold separately, bought separately, transferred across state lines, held by someone who has never set foot on the property where the water is. Prior appropriation was invented during the California gold rush. Miners needed water to wash gold from rock. They diverted streams. The first miner to claim the water held the right against everyone who came later. The doctrine survived the gold rush. It became the foundation of water law across the western United States. It is still the foundation today. Most Americans living in the West today inherited the legal system of 19th century gold mining. The American legal system allows property to be split, not just sold to different people, but legally divided into separate categories of ownership. The land surface, the minerals beneath it, the oil and gas, and in many states, the water. This is called a severed estate or a split estate. The land surface belongs to one party. What is underneath belongs to someone else entirely. In states with severable water rights, the family that owns the farm may not own the well. The community that lives above the aquifer may not own the aquifer. The homeowner who pays the property tax may not own a single drop of the water beneath the lot. And under American law, the mineral owner, or in this case, the water owner, generally has the legal right to access their property, to drill, to pump, to extract. The surface owner, the homeowner, the family that lives there, can be required to allow it. There are limits. Some states have reasonable use rules. Some have permit systems, but the foundation of the law remains. The water under your house, in much of America, is not yours. To see what severed water rights look like in practice, look at western Arizona. In 2014, a company called Fondomonte Arizona purchased nearly 10,000 acres of land in La Paz County for approximately $47 million. Fondomonte is a subsidiary of Almarai, a dairy company headquartered in Saudi Arabia. Almarai needs alfalfa to feed dairy cattle. Growing alfalfa in Saudi Arabia is now restricted because of how much water it requires. So Almarai sends its subsidiary to grow alfalfa in the American desert, where the water rights are more permissive. The wells Fondomonte operates can extract up to 64,000 gallons of water per minute. In 2023 alone, Fondomonte used approximately 31,000 acre-feet of groundwater from one Arizona basin, according to the lawsuit later filed by the Arizona Attorney General. This constituted over 81% of all groundwater extracted in the Resnicks Basin that year. The alfalfa was harvested. It was shipped to Saudi Arabia. It fed cattle that produced milk for sale in the Gulf. The residents of La Paz County paid their own water bills. In October 2023, Arizona's governor announced the state was canceling Fondomonte's land lease in Butler Valley and would not renew 3 other leases. The state had found Fondomonte was pumping unchecked amounts of groundwater while in default on its lease. In 2024, the state attorney general sued Fondomonte under Arizona's public nuisance law. The lawsuit is still in court. In May 2026, a judge refused to pause it. Fondomonte continues to pump water from privately owned land in the same basin. If this is the kind of pattern you want to see exposed every Thursday, hit subscribe. The Saudi-owned farm became the most visible case. But it is not unusual, it is the pattern. In California's San Bernardino National Forest, the Swiss food multinational Nestlé, operating through its subsidiary now called BlueTriton brands, has extracted water from springs in the headwaters of Strawberry Creek for decades. The water is sold under the Arrowhead bottled water label. In 2017, the California State Water Resources Control Board found that Nestlé had been diverting water for years without a valid legal basis for most of what it took. The state's report concluded the company had the right to take about 26 acre-feet per year. The company had been taking up to 192 acre-feet per year. The investigation continued. The bottling continued. In Central California, a company called The Wonderful Company, owned by Stuart and Linda Resnick, owns the largest farming operation in the western United States. The company grows pistachios, almonds, mandarin oranges, and Fiji water. The Wonderful Company also owns substantial groundwater rights in California's Central Valley and is among the largest controllers of water in the state. During the multi-year California drought, when residents were under mandatory water restrictions, the Wonderful Company continued large-scale agricultural pumping under its existing water rights. The pattern is consistent across the western United States. Foreign-owned agribusiness, American-owned private equity, multinational food and beverage corporations. They acquire water rights that the legal system treats as separate from the land. They pump. The communities above the same aquifers ration their use, pay their bills, watch their wells run lower. Water rights enforcement in the United States falls almost entirely on state agencies. Most of those agencies are understaffed, underfunded, and operating under doctrines written in the 1800s. In Arizona, the state did not designate the Resnicks Basin as an active management area, the legal mechanism for regulating groundwater pumping, until January 2026, 12 years after Fondomonte began operating there. In California, the Sustainable Groundwater Management Act was passed in 2014. Implementation timelines extend into the 2040s. By then, several major aquifers will have been further depleted. For most of American history, groundwater was treated as effectively unlimited. The laws reflected that assumption. The science later proved it wrong. The laws did not catch up. When a corporation drills a deeper well than a homeowner can afford, the corporation gets the water and the homeowner's well runs dry. In most states, the homeowner has no legal claim against the corporation. The corporation was using its right, the right that was severed from the land long before the homeowner bought the house. Why does the system continue this way? The answer is the same answer that explains most of what the Dark Vault investigates: money. The global bottled water industry generates over $300 billion annually. Almarai, Fondomonte's parent company, reports annual revenue of approximately $5 billion. The Wonderful Company is privately held but estimated to generate over $6 billion in annual revenue. BlueTriton was acquired by private equity firm One Rock Capital Partners in 2021 and recently merged with Primo Water in a deal valuing the combined company at over $6 billion. The pattern is global, but the water is local. Every gallon pumped from an Arizona basin, a California spring, an Oregon aquifer is a gallon that was once available to the community above it. The legal doctrine that allows this extraction was designed for 19th century mining camps. The corporations using it today are not mining camps. They are some of the largest agricultural and beverage operations in the world. The doctrine has not been substantially rewritten. The corporations using it have grown. The communities above the aquifers that have not received compensation, have not received water credits, have not received meaningful federal protection. They have received water bills. The defenders of this system argue that prior appropriation works, that without it water in the arid West could not be developed. that the certainty of severed water rights is what made Western agriculture possible. Some of that is true. A water rights system has functions worth preserving, but that is not the system that exists. What exists is a legal framework built for 19th century mining camps, used in the 21st century by foreign-owned agribusiness, multinational beverage corporations, and private equity firms. A framework where the homeowner who lives above an aquifer has fewer legal rights to that water than a corporation that has never set foot on the land. A framework where the residents of La Paz County, Arizona, watched their water tables drop while a Saudi-owned company pumped 81% of one basin's groundwater to grow cattle feed. A framework where the residents of Strawberry Creek, California, watched a Swiss-owned bottling operation take more water than the state believed it was legally entitled to take. A framework where the residents of California's Central Valley watched their wells run dry, while one private corporation continued extracting underrights that predated their houses. And the Americans living above the water, the ones whose communities depend on it, are paying for the extraction with their wells, with their property values, with the long-term viability of the places they live.